I'd like to welcome everyone to the law school. We're delighted today to be part of the Brennan Center Jorde Symposium, which is an annual event that takes place at 2 locations each year. Every year it's at the University of California, Berkeley, and this year it's at the University of Chicago Law School. And the symposium promotes top scholarly discourse and writing from a variety of perspectives on issues that are central to the legacy of William J. Brennan, Jr. And we at the University of Chicago have a rich connection to the legacy of Justice Brennan. 9 of our alumni have served as clerks, beginning with our own Jeff Stone in 1972. And when you add our faculty to the equation, we get up to 10 with Judge Richard Posner, who also clerked for Justice Brennan in 1962. And today's symposium features Judge Posner of the U.S. Court of Appeals for the 7th Circuit, who's also a longtime faculty member, all of you know, at the law school. And I have to say, when I came over to the law school about 1.5 years ago, it was really a goosebump moment for me when I met Dick. I think before I decided to come here, I think I was being recruited, and Dick walked in, and he had a 10-point plan for the law school, and we sat down, very organized, went through, I agreed with 9 3/4 of the 10 points. And then last year, I think on the 1-year anniversary of the 10-point, I came to the law school, obviously, and then a year afterwards, we sat down, and I brought the 10 points to him, and I had a little progress report on each of the points, and so he then turned around and said, that's good, and then let's do the following. So Dick is someone who both loves the law, loves Chicago, loves the legacy of Justice Brennan, but also loves our law school deeply, and we love him back. And we're really, really delighted to be able to host this today. Now, a unique aspect of this symposium is the participation of 2 panelists or commentators. Lee Epstein, the Henry Wade Rogers Professor at Northwestern School of Law, the most eminent scholar of judicial behavior, and also someone who co-teaches a seminar with Dick and with Bill Landis for our students as well as Northwestern students, and it's been meeting all year. And I think you're now done, right? Or almost done. So she is going to be one of the commentators, and Professor Aziz Huq, who is an assistant professor of law at the University of Chicago, an amazing scholar and teacher, and actually former director of the Liberty and National Security Project at the Brennan Center, will be the other commentator. Now, following the reception, so we'll have the talk, comments, sometime hopefully for some questions, so start thinking of the good ones, and then what we'll do is we'll have a reception immediately following out in the court, out in the area outside the courtroom. So it's now my pleasure to ask Dick to come up and speak on the rise and fall of judicial restraint.
Thank you very much. It's a pleasure to be here. I hope I'm audible. So I'm going to talk about well, it's really a corpse. It's a corpse of James Bradley Thayer. It's the Thayer tradition of judicial self-restraint. Very prestigious tradition, very distinguished members of it. But it died, surprisingly, at the age of 81, and I'm interested in exploring that. So I have to start by saying a few words about the concept of judicial self-restraint. It has at least 3 separate meanings, 2 of which are really quite important to my discussion. So the first is that judges just apply law, they don't make law. And that I call the law made me do it. The second is that judges defer to a great extent to other officials in government. Appellate judges defer to trial judges and administrative agencies and so forth. And this is judicial self-restraint as modesty or as preoccupied with institutional competence or as process jurisprudence. And the third concept, which is my focus, is that judges are highly reluctant to invalidate statutes. This is constitutional restraint. Very high level of deference to the legislature. And this third, as I say, this third concept of judicial self-restraint is the one I focus on. Now, there's a conflict between the first and the third, between law made me do it and constitutional restraint. That's very important to my discussion. Because if you believe that the law prescribes all the judgments that judges have to make, then there really isn't any particular room for a doctrine of deference toward constitutional provisions. They're either constitutional or they're unconstitutional. No reason to bend in favor of one or the other. So the most illustrious aspect of the third concept of self-restraint, the constitutional restraint, is the Thayer tradition. Began with an 1893 article by James Bradley Thayer, professor at Harvard Law School, and called The Origin and Scope of the American Doctrine of Constitutional Law. And in it he argued that a statute should be declared unconstitutional only if its unconstitutionality is, quote, so clear that it is not open to rational question, close quote. That's his formula. The concept didn't actually begin in 1893. It's much earlier, but Thayer gave it form and he defended it, and so he's the beginning of a kind of self-conscious tradition of restraint, of constitutional restraint. It flourished, this doctrine of judicial restraint, at a time when judges really didn't have any systematic ideas about how you decide a case. There were no constitutional theories. That was its strength, actually. It died, I'll explain, extent time permits, died in 1974. First, because it rested on false premises about the nature of legislatures. That was a weakness. It had no real coherence. The Thayerians, as I'll show, they didn't agree with each other, actually. It wasn't a unified body of doctrine. Third, it had no stopping point. Once you embrace the notion of not invalidating any statute unless its unconstitutionality is beyond rational question, it turns out that there are no statutes that can't be defended. We actually have now, Thayerism is dead, but a kind of ghost or vampire exists, the hyper-Thayerians. Good example is Adrian Vermeule, Harvard, formerly of this school. They believe, in fact, there are no unconstitutional statutes. And Vermeule argues that Brown versus Board of Education was incorrectly decided because a proper application of Thayer's theory would have upheld the statute as not beyond rational question. But I won't discuss the hyper-Thayerians. And next, it was vulnerable to the rise of constitutional theory, that is, to theories that would tell judges how do you decide a constitutional case. And that would strengthen the type 1 restraint. The law made me do it. If you had a formula for deciding whether a statute was unconstitutional, there would be no reason to have this rational question formula. That's a formula of doubt, skepticism. And last was a combination of the very liberal decisions of the Warren Court with the refusal of the conservative successors of the Warren justices to adopt a kind of ratchet theory of constitutional evolution, where the liberals expand the Constitution through, daring interpretations, and then the conservatives, being conservative and believing in adherence to precedents, they ratify the radical forays of their liberal predecessors, so that you have a constant increase in the liberal interpretation of the Constitution. So all these things doomed Thayerism. I'm going to discuss just 5 Thayerians. Thayer himself, Oliver Wendell Holmes, Brandeis, Frankfurter, and Alexander Bickel. And there are others, many others, but these are sort of the 5 main figures in this 81-year-old tradition of constitutional restraint. So Holmes was his immediate successor. He had practiced law with Thayer for a period of years. Then, of course, he's followed by Brandeis, then Frankfurter, and Bickel. So this is the tradition. Now, Thayer based his theory of constitutional restraint on a number of points, but the foremost of them was his claim that if courts enforced constitutional limitations on legislation to the limit, that would make the legislature stop thinking about constitutionality. It would sort of infantilize them. So what he said, I'm quoting, "The checking and cutting down of legislative power by numerous detailed prohibitions in the Constitution cannot be accomplished without making the government petty and incompetent. Under no system can the power of courts go far to save a people from ruin." Or as he put it later, "The tendency of a common and easy resort to this great function, judicial review by courts of constitutionality, now lamentably too common, is to dwarf the political capacity of the people and to deaden its sense of moral responsibility." This is a little like one of the reasons that's given for deferential appellate review of trial court fact findings, that that deference encourages the trial judges to be more thoughtful because they're more responsible. So Thayer obviously had a high opinion of legislative deliberation as long as it wasn't impeded by aggressive interpretation of constitutional limitations. There are actually 2 points here that Thayer was making. First, that legislatures really do deliberate, and secondly, that their deliberations are impeded by aggressive judicial review. And that's probably both points are wrong. They don't deliberate, and therefore nothing that the courts do is going to impair their deliberation. Holmes, interestingly, in his private correspondence, he declared himself a follower of Thayer. He said that his constitutional philosophy was identical to Thayer's. And in fact, in a number of opinions, for example, his dissent in the Lochner case, he actually repeated the Thayer formula, the rational question formula, virtually literally. But there's something wrong with that, because he didn't buy any of Thayer's premises. He didn't admire legislatures. He didn't think they had potential. He didn't like the laws they ground out. He didn't think they had any potential to be thoughtful interpreters of the Constitution. He didn't think that they reasoned. He thought that legislation was merely a litmus which recorded the balance of political power in the community. His opinions, first on the Massachusetts Supreme Judicial Court, then in the U.S. Supreme Court, upholding all sorts of social welfare legislation, made Holmes, kind of the apogee of judicial self-restraint, because he, in his private correspondence, he would say how much he hated those laws and just upholding them because it was his duty. But I don't think that's true, actually. It wasn't that he liked the laws. It wasn't that at all. It was that he was a Darwinian, and he thought that the laws simply represented the balance of power. You observe laws the way you observe animal populations to see, what is surviving in the Darwinian jungle. And he was a tremendous Darwinian. Buck versus Bell, 3 generations of imbeciles are enough, right? He wanted to improve the race by not allowing imbeciles to reproduce. He was quite frank about it. He really liked that decision of his, really proud of it. I thought that was great. But he understood that Darwinism is a theory of adaptation rather than a theory of improvement. So it wasn't that he thought that judicial rulings invalidating legislation would make public policy worse. It's that it was just interfering with the natural process of evolution, which operated in the human sphere as in the animal sphere. So it is a very characteristic quotation. He says, "All that can be expected from modern improvements is that legislation should easily and quickly, yet not too quickly, modify itself in accordance with the will of the de facto supreme power in the community. The more powerful interests must be more or less reflected in legislation, which, like every other device of man or beast, must tend in the long run to aid the survival of the fittest." There's an explicit Darwinian theory of the legislative process. It's completely opposite to Thayer's notion of legislators as serious deliberators thinking about the Constitution and so on. So I don't know how you can call him really a Thayerian. So Brandeis comes next, and he's often bracketed with Holmes, and they were friends. They agreed on a lot of results. Brandeis was actually a former student of Thayer, the Harvard Law School, but he was completely different from either Holmes or from Thayer. He was political. He was extremely political. He was a Jeffersonian. He had a Southerners' hostility to strong central governments. He was from Kentucky. He's not your typical Kentuckian, but he was a Jeffersonian. Anti-bigness, hated finance, hated chain stores, hated big business. Now, these antipathies of his were shared by a lot of state legislators at the time, and they were more liberal, the state legislatures, more liberal than most federal judges. So Brandeis, finding himself a liberal minority in a very conservative court, embraced judicial restraint. That is, he wanted the courts to leave these state legislatures alone because he liked their policies. And the way in which he embraced his distinctive contribution to the Thayerian tradition was to advocate all sorts of doctrines that limited access to the court, so it would make it less likely to have occasions on which state legislation would be brought before the Supreme Court and risk being invalidated. So when you think of the series of doctrines, standing, ripeness, avoidance of unnecessary constitutional rulings, refusal to decide political questions, all of these are doctrines for limiting a direct confrontation between a legislation and other executive legislative action and judicial review. None of these doctrines are in the Constitution. None of them have any, actual English origin. They're all made up by American judges, beginning actually before Marshall. But Brandeis made a big contribution to them. And as I say, this was his contribution to judicial self-restraint. When these avoidance measures failed and the constitutionality of the state statute was directly presented to the Supreme Court, then Brandeis, would trot out a lot of statistics to try to show that this was a good policy, right? He was political. So Frankfurter, the next in the line, he was very, very political also, like Brandeis. He was the most vocal exponent of Thayerism. He was far more passionate in his advocacy of Thayer. His Thayerism there was a link with Thayer in he was very much part of the progressive movement. He believed in expertise. He thought of legislators as experts, and what they would do would be on the whole good. He wasn't really restrained across the board. He was just restrained with legislation that he liked. So when it came to the Fourth Amendment and the Equal Protection Clause, he was not restrained, and of course he was passionate in support of declaring public school segregation unconstitutional. So he was an opportunistic Thayerian. There is another aspect of it. He was less emphatic than Holmes and Brandeis, but both of them made another good, I think, contribution that outlived Thayerism, which was the notion that going light on state legislation contributed to experimentation at the state level, diversity. And you could learn. You'd learn what were good policies by observing the different responses of the states to common problems. Brandeis, I think, was interested in this kind of experimentation because he thought we'd learn a lot, and that would enable the courts and the other branches of government really to pick the best policies. I think for Holmes it was different. I think Holmes was preoccupied with evolution, and he saw an analogy to variation, right? You need variation for evolution. So if the states did different things, then the powers would somehow choose, the evolutionary process would decide which was the most successful and be adopted by the other states. Well, the last Thayerian I discuss is Alexander Bickel, who's a law clerk of Frankfurter and a loyal acolyte. And he makes many approving references to Thayer, just as Frankfurter did, and Holmes and so on. But I don't think he's at all a Thayerian. I don't think he's a kind of tactician, right? He talked a lot about principles, but his idea of principles really, he had political ideas. He felt himself to be in the vanguard, the ahead of the time, a more thoughtful, progressive thinker than hoi polloi. But he thought of the Supreme Court as a body which could impose, advanced thinking on the culture, but it could do so only very, very slyly, because the Supreme Court, and this was a political science insight, a valid insight, was in competition with other branches of government. So it had to be very clever in the way it changed public opinion. And he made ingenious suggestions. For example, that the Supreme Court shouldn't take a case in which it would have to affirm a decision that was not progressive, because the dopes would think that if a statute is constitutional, it's good, not merely that it's constitutional. So he didn't want, so because a judgment of constitutionality would be misunderstood, he wanted the Supreme Court deliberately deduct cases which would require them to give us what people would consider a stamp of approval to a bad law. And he had these other tricks, of course. This notion of a kind of coercive dialogue between the Supreme Court and the states. So this idea that, well, he suggested striking down the Connecticut birth control statute that was later struck down after he wrote in Griswold versus Connecticut. He thought the way to deal with that was to say that, well, it hadn't been enforced. And if a law isn't enforced, it dies. Called the doctrine of desuetude. So the courts would declare the statute abrogated because of desuetude. Then, of course, the state could, in principle, reenact the statute and enforce it. Right? So he'd be saying to the states, the Supreme Court would be saying, well, you can't enforce this statute because you have never enforced it before, and people are fooled and so on. But you could pass it and then enforce it, because he knows the inertia of the legislative process would prevent that. Public opinion had changed and so on. Actually, he was wrong. The Connecticut birth control statute was very effectively enforced. It prevented the creation of birth control clinics. Women could still go to a gynecologist to get a diaphragm, but people who didn't have their own gynecologist couldn't get female contraception because there were no birth control clinics. Well, Bickel died in 1974, and I date the death of the Thayerian tradition to his death because I think after that there really isn't anything more to it, and for several reasons. So one reason is that the Warren Court in the 60s had greatly expanded the reach of constitutional law, and you could hardly expect the conservative justices that followed the Warren justices, as I said earlier, simply to say, well, all right, now it's the law, and we have to follow it, and so on. No, they would try to carve it back. They would not be restrained from doing so. They would, respect precedent to a degree, just for the public relations of the court. And as the court continued to move rightward, it would become aggressively unrestrained. Example I particularly use is the Heller case, the enlargement of the Second Amendment to create a right of private ownership of guns for personal defense, and also the Citizens United case. There's just a number of cases in which a right-leaning court has embraced aggressive constitutional interpretation of the character of the Warren Court, but with the opposite political valence. And what has assisted this process, the abandonment of judicial restraint as any kind of doctrine, is the rise of constitutional theory. It really is remarkable the number of constitutional theories that are jousting for supremacy. So we have originalism of Bork and Scalia. We have Judge Easterbrook's textualism, embraced in different forms by other people. We have John Hart Ely's representation reinforcement. We have Breyer's Act of Liberty. We have the Constitution as common law. We have the living Constitution. We have the Constitution in exile. We have minimalism. And all you have to do is pick one of these, and it will tell you how to decide the cases. And as Ronald Dworkin says, even the most difficult legal questions have right answers, right? So you pick your machinery for generating the right answers, and then you decide what statutes are constitutional. And to say, well, I think the statute is constitutional, but I have no great confidence. There's no, how do you decide whether a statute is constitutional? Therefore, I'm going to defer, unless I think it's, irrational, totally irrational. That line assumes an absence of cogent theoretical machinery for generating constitutional decisions. And that's harder to do because then someone will say, well, why don't you choose one of these theories? Then it'll tell you whether its statute is constitutional or not. You can't just refuse all of them, right? They occupy the entire field of potential thought, right? Pick one of them. The obverse of this is that I don't think the judges in the Thayerian tradition had any constitutional theory at all, which I actually think is a strength. I don't think they knew how you interpret a constitution. Holmes famously said in a letter, and put in an opinion, he said in a letter that he would vote to uphold the constitutionality of a statute unless it made him want to puke. And this is actually not quite Thayerian, because a statute that you couldn't say was totally irrational might make Holmes puke, then he'd have to invalidate it. But it's an example of judges saying that that it's just you react to a case. You have to decide a case. That's the basic duty of a judge. You have to decide. You can't say, well, I can't decide this case. I can't think of any. I don't have any law to apply. Right? The lawyers come before you and they argue the case, and you say, well, I don't know what law to apply here. It's all very vague. So you just go home and, no law to apply today. We're going to lunch early. So you can't say that. So I call these judges, these atheoretical judges, pragmatists, and I think they're not in a pretentious philosophical sense, but just people who don't have a master theory. Obviously, they listen to the arguments that the lawyers make, and they think of their own reactions, what they know about the subject, and they they're interested in consequences of alternative rulings, and they just do the best they can. And I think if you go back to the 19th century and 18th centuries, before the age of law clerks, and when academic law was a very limited subject, you find very little about theoretical grounds for generating judicial decisions. It's all very, very casual. So as I say, when you have the Warren Court's extremely flexible and radical interpretations of the Constitution, and then you have the right-wing backlash to that, restraint really goes out of the window. And when in addition you have this elaboration of constitutional theories for deciding cases, then the judges feel that they have ways of making cogent decisions. They don't have to worry about whether there's a slight rational basis. But so judicial self-restraint is dead. certainly dead on the Supreme Court. There are no restrained Supreme Court justices. The last, probably Justice Harlan in the 60s. There's one Court of Appeals judge, Judge Wilkinson, the Fourth Circuit, who has denounced both Roe versus Wade and the Heller decision as being unrestrained. Maybe there are a few more here. There must be a few more, hundreds of judges, but it's pretty dead. But it has a legacy, because a lot of what the Thayerians did made a lot of sense. So the clearest of the Brandeisian avoidance doctrines, his elaboration of concepts of standing and rightness and so on. So those have endured, and those have limited the occasions on which the Supreme Court is in a position to invalidate a state or federal statute. So that's a real legacy, I think, of Thayer. I think pragmatism is in the sense that the Thayerian judges were pragmatic, and because they were distinguished judges, there is still, sympathetic or respectful reference to their efforts to deal with issues without fooling themselves. They had a really cogent method of decision. The idea of Holmes and Brandeis that there's value in experimentation, in allowing different states to have very divergent public policies so that you learn a lot. You learn as a matter of social science. You're able to compare different solutions to similar problems. That's a virtue, and you just learn in a cruder sense from seeing which seem to be working. That's a form of judicial restraint, I think, significantly, which is the base for significant criticism of the Heller decision, because of the extraordinary diversity in gun culture across the United States, in the social conditions regarding use of guns, the danger of guns in different parts of the United States. Now this is being homogenized. In addition, as the Thayerians recognize, there are some pretty good reasons for judges to be generally timid about invalidating laws and regulations. The justices are competent lawyers, but rarely more. Right? They're limited people. Judicial decisions can be rich in unintended consequences. Very hard to foresee what will eventuate from a decision invalidating a statute. The parts of the Constitution that generate litigation are antiquated and ambiguous very often, leading the judges into wholly futile and arbitrary investigations of 18th century history. And the issues presented in constitutional cases tend to be so emotional and so momentous in their potential social consequences that they engage the judge's emotions very deeply, and analysis tends to follow emotion rather than precede it. And of course, we know that unrestrained judicial decisions generate unrestrained backlash, right? So the Warren Court generates the Roberts Court in a sense, which is an aggressive court going in the opposite direction. So as I say, to summarize, this is an interesting tradition. It had its day, its moment in the sun, but it had internal weaknesses, and finally yielded to external effects, rise of constitutional theory, and the Warren Court. So now it's dead, but it does have at least a modest legacy, and there are values in it which we can continue to appreciate.
Judge Posner has expressed a long-standing interest in judicial self-restraint. And coincidentally, political scientists, and I am a political scientist, share that interest. And that's because the study of judicial behavior really takes off as a result of a debate in the 1960s over judicial restraint. Now, I have to say, to call it a debate is probably putting it a little mildly. It was something like disciplinary civil war. On the one side were the old guard legalists who had dominated disciplinary discussion of law and legal institutions for a very long time. And on the other side were the sort of new rebel quant realists who came loaded with all kinds of data and statistical methods. Now, in this particular debate over judicial restraint, it was the realist in the personage of Harold Spaeth who took the first shot. In an article, that's the Spaeth article, that's Justice Frankfurter, not Spaeth. But in an article he published in 1964, what he wanted to do was demonstrate that Frankfurter was no more of a restrainist than McReynolds and the other three horsemen. That, well, Frankfurter would be happy to uphold laws that comported with his values, but hardly reluctant to strike down laws that were not within his value system. The larger takeaway, I think, of Spaeth's article was that if Felix Frankfurter wasn't a restrainist, no one was. It was all just a big myth, a big smokescreen, another smokescreen, behind which the judges hide their ideology. The legalist in political science went ballistic with this article, especially one Wallace Mendelsohn. Just 3 years before this article was published, Mendelsohn had published a book on Frankfurter in which he said, "Frankfurter is the supreme restrainist. He resolves all reasonable doubt in favor of sister organizations of government." So when Spaeth published this article, Mendelsohn was not going to take it sitting down. And he came back in one of our prominent journals and published an article lambasting Spaeth and the other realist quants. Harold Spaeth, if you know him, is also not one to take criticism sitting down. He shot back quickly. Mendelsohn shot back. Finally, this started to escalate out of control, and the editor stepped in and stopped the debate. Okay. The editor I think he was right. I think Mendelsohn and Spaeth never saw eye to eye on the subject of judicial restraint. But ultimately, Harold Spaeth won the war, both in terms of the direction political science would take, and also, I think, about Felix Frankfurter and judicial restraint. It was all just one big myth. Noah Feldman, in a recent book, adds a little icing to the cake when he tells us how and why Felix Frankfurter discovered Thayer. Okay. So everything seems nice and settled, and into this mix comes Judge Posner stirring up a little trouble. Okay. Not, I think, in the debate over Mendelsohn, the debate between Mendelsohn and Spaeth over Frankfurter. I mean, as Judge Posner said in his remarks today, Frankfurter, while an adherent of Thayer, was also somewhat manipulative in his application of Thayerian principles. But what Judge Posner does do today is offer some provocative thoughts about judicial restraint, mainly that it existed, though not necessarily in a pure Thayerian terms, maybe at least as a pragmatic sort of tiebreaker, but that it no longer exists, that it has been supplanted, or was at least for a time supplanted, by exuberant judicial activism and more recently with constitutional theories. These ideas are testable, and what I did in preparation for these comments today was go out and try to test them with the help of my friend Bill Landis. What we did was we collected a bunch of data. We looked at cases in which the court considered the constitutionality of a federal law between the 1937 and 2009 terms. It's 645 cases, about 5,600 votes cast by the judges. There's lots of problems with the data, and some of the trends I'm going to talk about in a second. It's a little bit of a crude, I think, and incomplete test of Judge Posner's much more nuanced ideas. But I think we can learn something from the data, and let's see what we found. I'm going to start with the fraction of cases in which the court reviewed a constitutionality of a federal law, and I've just, for purposes of display, divided it into the 6 Chief Justice eras in the data set. Okay, so there's 2 things to notice. One is the fraction is fairly consistent over time. So we have, let's see if I have my pointer, we have the Warren Court in about 6% of its cases that were orally argued, it reviewed a federal statute. Maybe we're up to about 9% during the use court, but it's still a very consistent pattern over time. The fraction is also very small, which may lead to the conclusion that, in fact, the court has been pretty consistent restrainist, or at least it's not mucking around in Congress's business too much. That's an interpretation I'd probably resist because we don't know a lot about the court's overall docket during this period. What I can tell you, I can look at, is the fraction of laws that the courts actually struck down during these periods. And I think here we start to get closer to Judge Posner's story. I almost called you Justice Posner, gave you an elevation. Judge Posner's story. It almost looks like there's 2 court eras, 2 post-New Deal court eras, where we've got the Eustone and Vincent courts striking down very, very small fraction of laws before them, and then these later courts, and the current court, of course, is the most assertive during this period, and some people suggest the most assertive court of all time. Now, this is interesting. But I can tell you, I know Harold Spaeth pretty well, and I know exactly what he would say if he were here. He'd say, Lee, this proves absolutely nothing. The reason it proves nothing is that during these periods, right, you had liberal justices reviewing liberal laws passed by liberal Congresses, and so of course they're going to uphold them. Now I have to tell you, Harold is right, or there's some truth to what he says if you look across the whole data set. It turns out liberals are very faithful and happy restrainists when it comes to liberal laws. Right? So here, this is the judge's ideology down here. If you just look up here, these are the liberal laws and the liberal judges, and you can see in about 90% of the time they're going to uphold those liberal laws. Not so much when it comes to conservative laws. Here are the liberal judges here, and so we're talking upholding the conservative laws 20%, about 20% of the time. This is going to be true as conservatives as well. So score 1 for Spaeth. All right. It turns out, though, when you dig a little deeper into the data, the historical patterns that Judge Posner suggests emerge, and emerge in a very big way. We have enough data to consider, and I'm going to start here with the justices appointed by Roosevelt, Truman, Eisenhower, and Kennedy, so the first historical period. We have enough data to analyze the votes of 14. It turns out that 10 of them are restrainist in 2 ways. They are reluctant to strike down federal laws, And they're also not ideological about it. Their decisions to uphold or strike down don't reflect their particular ideologies. And it turns out Frankfurter's among them. Spaeth was wrong on that. The very interesting thing about Frankfurter, too, is that if you look at his behavior over time, from the Hughes Court to the Stone Court to the Vincent and finally Warren Court, he was a reasonably faithful restrainist. Flash forward. I've got data on 13 of the justices appointed since 1967 with Thurgood Marshall. 12 of the 13 I would consider ideological in terms of their judicial restraint. The one remaining justice is Lewis Powell, appointed in 1971. So Judge Posner, very close to your mark in your paper. Why did the shift occur? Judge Posner posits exuberant liberal activism and constitutional theory. Testing those mechanisms is going to have to wait for another day. But what I can tell you is that the activist liberals of the 1960s and the conservative theorists of today look a lot alike in terms of their behavior in reviewing federal statutes. But as Judge Posner would say, you already knew that. Thank you.
So it's reckless to say anything analytic about the behavior of judges in the wake of Judge Posner, one of our leading analysts of judicial behavior over the last few decades. And it's foolhardy to say anything empirical about the behavior of the federal courts in the footsteps of Professor Epstein. I almost called you Judge Epstein. Demotion, maybe. Or a promotion, depending on your perspective. It's foolhardy to say anything empirical about the behavior of federal judges in the footsteps of Professor Epstein. So my modest aim here is to point to some simple empirical facts in order to identify a little-studied question about the historical trajectory of judicial activism, and specifically to look back to a period prior to the one that Professor Epstein has focused upon. So I want to focus upon a descriptive question that is suggested but not wholly answered by Judge Posner's lecture. When across the spectrum, across the span of American history, was judicial self-restraint? If the present day is post-lapsarian, when was Eden? Most studies of the activism-restraint pairing focus upon the 20th century because that's when the best data is available. And in that time frame, as Judge Posner's lecture suggests, the standard view is that the judicial demise of Thayerian theory is attributable to the exuberant activism of the Warren Court. Yet one utility of Judge Posner's lecture is that it opens up the historical horizon of inquiry back into the 1800s. And going further, it could be asked, how has the incidence of judicial activism, as it's defined by Judge Posner, varied since Congress created the federal courts in 1789? When, that is, did restraint fall and activism originally rise? Now, the data on that descriptive question is very sparse, and his current understandings of the longue durée of the federal judiciary's movement across a activism-restraint spectrum are thin. The extant studies have substantial methodological and conceptual problems, and they allow only a tentative hypothesis, albeit one at in some tension with the culprit fingered by Judge Posner. So a first cut answer can be drawn from the canonical catalogue of cases in which the Supreme Court has invalidated federal law. That's a list that's maintained by the Federal Congressional Research Service of the Library of Congress, a list that is current up to 2002. This is a simple manual count of that data up through the year 2000. And I'll return in a moment to some reasons why you might want to distrust this chart. But let's just look at it for the time being. This Library of Congress data suggests that indeed the Warren Court was a moment of discontinuity in levels of activism. But it was not necessarily the beginning of judicial activism. There is, before then, the familiar rise and fall of economic due process. But even that storied moment cannot lay claim to judicial activism's origins. The demise of judicial self-restraint appears rather earlier. Notice that around the Civil War, and I'm sorry that the axes are not more clearly visible, around the Civil War there is a marked shift in the trend line. Before the war, judicial activism is at negligible levels. After the war, the trend line for activism is generally, although not wholly consistently, on an upward gradient. Now, two political scientists, Tom Clark and Keith Whittington, have challenged the Library of Congress data as under-inclusive. Now, I don't have a slide of their data, but it suffices here to say that the graphic that they generate, focusing only on federal laws, is surprisingly similar to the one that you see up here. Even with more antebellum cases in the mix, there nonetheless appears to be a turning point in judicial behavior around the Civil War. One further data point is helpful. My colleague Adam Samaha has observed that there is often a time lag between an amendment to the Constitution being ratified and the court interpreting that text. And he's compiled a list of cases in which such meaningful first contact occurs. Again, this is a simple tally of those cases. And of relevance here, the highest peak is in the 1870s. Now, before drawing some very tentative implications from these data, it is worth emphasizing their considerable limitations. Not the least, both the federal data and the Clark-Whittington data have shortfalls when it comes to providing information about their coding protocols, something that I know Professor Epstein has been very critical of in other contexts in the past. But equally significantly, the data, both of these sources of data, allied important conceptual questions about how best to count judicial activism. For example, students of statutory interpretation know that what is denominated an invalidation is endogenous to prevailing conceptions of judicial craft. A wide array of statutory interpretation tools allowed judges, since the Ellsworth Court at least, to apply constitutional norms without making explicit findings of invalidity. So when should such decisions count as activism? More importantly, the data here beg the question of activism in comparison to what? Against what benchmark, that is, should activism be measured? After all, the volume of federal and state laws changes over time. As statute books engorge, perhaps the need for judicial review grows correspondingly. Or if legislatures are conscientious, perhaps it does not. The historical growth of the federal regulatory state might also be significant. And note that the textual bases for invalidation under the federal Constitution change. They enlarge as the Constitution is sequentially amended. A pure headcount approach, such as this, to judicial activism elides important conceptual puzzles that are embedded in the definition of judicial activism. So with those caveats, let me offer a tentative conclusion. Judge Posner has emphasized not so much Thayer's significance to judicial behavior, but what he calls the exuberant Warren Court as a turning point in the historical trajectory of judicial activism and restraint. And the point is not without force. It is also a familiar one in the legal academy, where the Warren Court is alternatively celebrated or trashed for its criminal procedure and equality rulings. Yet, a generation of scholars who came of intellectual age in the Warren Court shadow may have overestimated its catalytic role as the beginning of a ratchet. To understand the origins of judicial activism, it may be wise to go back even further, before the Lochner era, before Thayer, to the aftermath of the Civil War, a time when Dred Scott v. Sandford was still raw in the legal consciousness. If there is a post-bellum period in which a significant change occurs in the behavior of the court, and if that change is the birth of activism as it's defined by Judge Posner, what might explain such a transformation? Regrettably, the habitual periodization of comprehensive legal histories, such as the Holmes device, obscures the question. More historical attention has been lavished on the Civil War as a freestanding constitutional crisis than on the shifting patterns of judicial behavior on either side of the conflict. Nevertheless, it seems fair to say that the war marks a hardening in the court's approach to constitutional questions. One manifestation of that change, although not the only one, is a series of confrontations with the Congress. Abruptly, the court, the postbellum court, is engaged in superintendence of Reconstruction, consideration of new forms of federal paper currency, review of a wave of federal civil rights measures. It is suddenly posing a threat to the agenda of a national political coalition. Non-quantitative studies are further suggestive in pointing to a change in the rhetoric of judicial decisions at that time, with judges being increasingly candid about both their willingness and their power to invalidate statutes. Now, there are diverse hypotheses that might explain this change, that might explain why this is a moment of change. And I can offer no more than some suggestions here. As a threshold matter, I am not persuaded that it is the Reconstruction Amendments that are the platform for the efflorescence of judicial activism at this moment in time. Consider that after the Civil War, it is not until 1880 that the court first invalidates a state enactment based upon Reconstruction Amendment grounds. Yet in the intervening years, between 1865, when the war ends, and the first of the Reconstruction Amendments is enacted, is ratified, and 1880, in that 15-year span, there are 44 other state laws that are invalidated based on provisions of the antebellum Constitution. And after 1880, it's another decade and 33 more antebellum constitutional invalidations before the Supreme Court evokes the 14th Amendment again against a state law, now on economic due process grounds. So one alternative story might emphasize the moral hazard effect of the court's newfound political stability. Perhaps Dred Scott taught the apex federal bench a lesson, that it could make dramatic inroads on important national questions, and even if the results were catastrophic, still survive with scant long-term damage. An alternative possibility is that the post-bellum period may have seen a confrontation between an ancien regime court, still largely staffed with a pre-war majority. The Reconstruction Congress was never able to appoint a majority of the US Supreme Court. A confrontation between an ancien regime court and new constellations of radical political forces in both the elected legislature of the federal government and in the several states that bore the brunt of post-war invalidations.
Go ahead and call on people and you can address questions to whoever you'd like.
Yes.
I'm interested in the characterization of Holmes and Brandeis is pretty much there, even though you give reasons why it doesn't really fit their bill, but even as judicial restraintists. Because certainly on economic legislation issues, on Lochner issues, they fit that description. But on other areas, most notably free speech and privacy, they were actually quite activist. So were they really engaged in anything that even remotely looked Thayerian, or were they too just being opportunistic and voting for and against the laws that they happen to like politically, as was suggested by Lee's data?
Yes, yes, absolutely. Yeah. Yeah, they talked the Thayerian line, and in the case of both of Holmes and Brandeis, when they were voting to uphold legislation, or when they were arguing, or when Brandeis was arguing for not taking the case, it wasn't properly before the court, they would use the Thayerian rhetoric. Yeah, I don't think there have ever been a consistent Thayerian.
I mean, how could
Except
you-
Thayer, I suppose. It wasn't a judge.
It was a judge, right. But did Holmes and Brandeis seriously invoke Thayer and not try to explain why they were completely and radically departing from it when it was convenient? Or are you
No.
attributing to them an invocation of Thayer that they themselves wouldn't have accepted?
No, as far as I know, the only reference to Thayer in Holmes is in his letter when he
Right.
said that he agreed completely with Thayer's view. That there's that, and in fact, the formula in Lochner, the way he puts it in Lochner is almost identical to Thayer's formula. So Lochner, Lochner, the greatest dissent in history, it's only a page long. It doesn't have anything that could be described as reasoning, really. But it has the statement that this is a law on which people whom I respect might think it reasonable, and therefore it should not be invalidated. That was good enough for him. So he's certainly being an orthodox Thayerian when he says that. But as you say, if you think about his free speech dissents, or his habeas corpus decisions, or his dissent in the Olmsted case, the wiretapping case, yeah, there's nothing about restraint there at all. No, yeah. Although what is interesting about his constitutional opinions, his free speech opinions, and the wiretapping, the habeas corpus, he almost never actually refers to. He never quotes the Constitution. Right? He never discusses the history of constitutional thinking. It's really a common law type of reasoning. So he fits my notion that judges of this generation didn't really have theories about how you decide cases.
Although Brandeis and Whitney does.
Isn't
Brandeis' opinion in Whitney explicitly talks about what we would today, I guess, call originalism. It goes back to the framework.
Right, that's true. Of course, his dissent in Olmsted has a very different
Right.
character, though. Yeah.
But Judge Posner, can I ask, isn't it true, too, that Holmes did distinguish between federal laws and state laws? Judge Easterbrook will probably remember his famous quote about, the country would be intact if federal judicial review went away, but not state judicial review, Lochner aside.
No, he had the opposite. He thought it was essential to have federal judicial review of state law.
Yes, what I mean.
Yeah.
Review of state laws, but
Right.
not federal laws.
Yeah, because otherwise it would dismantle the Constitution
Exactly.
if states could do anything they want.
I wonder why you characterize constitutional theory as a cause of the demise of self-restraint rather than an effect of it. So, I mean, after all, a lot of the judicial activism that all three of you have pointed to occurs well before the birth of a lot of the constitutional theories that you described. They come sort of in the wake of both the Warren Court and then this sort of later Frankfurter era activism. And I think a lot of people have described constitutional theory, and particularly some constitutional theories, as this sort of veil that justices are adopting to try to obscure what otherwise would look like naked, partisan, ideologically based judging. So why do you see? So I mean, but it sounded like you thought of the rise of constitutional theory as sort of an independent factor pushing against self-restraint rather than simply just yet another sort of manifestation of otherwise existing ideological trends. I was wondering if you could say a little bit more about that.
Your point is good, because certainly the justice of the Warren Court didn't need a theory in order to enact their political preferences, but there was pushback in that period in the '60s from Bickel in his own way and from Frankfurter and so on. They intoning the Thayerian litany. But then in the next decades, there is this additional weapon to use against judicial self-restraint, theories that the Academy is busy ginning out to justify, either justify what the Warren Court is doing, like John Ely's work, or to justify a form of aggressive constitutionalism going the other direction. The theories are not, in my opinion, the theories are not for real. They're rhetorical. And they provide a rhetoric with which to, not so much, with which to sort of change the subject from judicial restraint to conformity to constitutional doctrine. Frank?
Dick, did any of the Thayerians ever propose a serious change in the way that the court behaves? That is, Thayer's view, as he stated it, was not about how individual justices should behave. It was about how the court as an institution should relate to Congress as an institution. And if you want to change how the court as an institution behaves, you have to change the rules for what the court does. So you could, for example, say to each justice personally, vote however well, vote exactly for what you think the Constitution requires, right? Be a legalist, be a pragmatist, do exactly what you want. We're going to change the relation between the court and Congress by changing the voting rule, right? If you assume that the justices are all reasonable people, then a law would be valid if any one justice thought it was valid, because then it's a kind of law that would appeal to reasonable people. Only unanimous decisions set aside laws. Or if you wanted to flip this in Jeffersonian ways, you would say a law would be valid only if all 9 justices thought it was valid, right? But if you really want to change what the institution does, you don't appeal separately to Justice Powell or Justice Horace Gray. You do something about the institution. And my question is, have the Thayerians ever thought about voting rules and other institutional changes?
I don't think so. There is discussion of that from time to time. There have been suggestions for supermajority rules in courts dealing with particular issues, but I don't think any of the Thayerians I have never seen any suggestion they were interested.
More odd than that, there are of course a lot of members of the legislature who spend their time whining about what they perceive as intrusions by the judges, and they also make no proposals for changes in voting rules with the Supreme Court.
Yeah. Yes.
I can see clearly the difference or the antagonism between originalism and pragmatism. But I was wondering whether Thayerism or judicial self-restraint wasn't just another theory of constitutional law. If you add some institutional concerns of legal process and institutional fitness, isn't that sort of the theoretical underpinning of self-restraint, so that it is just something like a minimalist theory of constitutional interpretation?
Well, the problem is that Thayer's basic theory is that if the courts are too restrictive in their interpretation of the Constitution, as I said, legislators will be infantilized. The problem with that, you can't translate that into specific decisions, right? You're just saying the courts should be careful not to step on too many legislative toes, but you're not telling them how do they draw the line. This is why I give two examples. One is the hyper-Thayerians. They really begin with learned hand, and now we have Adrian Vermeule, and we have Mark Tushnet, we have a few others. So they say, well, this just means there shouldn't be judicial review at all. That's the logic of Thayerianism. And then the legislators, not having a crutch of a court that invalidates laws, they'll have to deliberate about constitutionality before they enact. That's the logic of it. But if you don't embrace that logic, where do you draw the line? I mean, they never said that, right? So, I'd say there's nothing in Thayer and you can turn it the other way. You can say, like a case like Brown versus Board of Education, Baker versus Carr. So you can say Baker versus Carr, the reapportionment problem. You can say, well, Thayer says we don't want to have, intrusive judicial review because we want the legislators to be thoughtful. But in a reapportionment case, the problem is that you have the dominance of the legislature by a minority. So if you think that's a bad thing, there isn't anything in Thayer which would say, well, leave it to the legislators. If you don't interfere with them, they'll deliberate more effectively. The sort of reductio ad absurdum is in Frankfurter's dissent in Baker versus Carr. He talks about searing the conscience of the legislators. In other words, you tell them, look, the court isn't going to do anything, but you should be really embarrassed that you represent a minority, but you're dominating the legislature. And that sears their conscience, and they feel guilty, and they reapportion. So that's obviously unrealistic. So as I say, the Thayerians never tell you where to draw the line. And so it's not a theory of how to decide cases. It just tells the judges when you're ruminating on these cases, just be worried because you may reduce the quality of legislative deliberation, and so you resolve doubts in favor of Constitution. That's really about what it amounts to: resolve doubts in favor of constitutionality, so that legislators will deliberate more. That's the whole thing in a sentence. You can see how it wouldn't really do much for judges actually involved in decisions, right? To be given that homily right there.
Before we break, let me just ask you, Dick, do you have any response to or any comments on the comments of Aziz or Lee with regard to your talk and data they presented?
Well, just very, very briefly, starting with Aziz. Yes, what it is that causes outbursts of judicial activity or unrestraint, right, and how it recurs periodically, or not irregularly throughout history. Yes, there's nothing unique about the Warren Court as a burst of judicial aggressiveness which would necessarily cause a reaction from another political dimension. So there must be many cases in which the court is riding high, being very aggressive, and others when it draws in its horns, becomes very timid. And with regard to Lee's point about, especially the comparison between the Warren Court with its huge number of invalidations and then the Roberts Court, I think the problem is the heterogeneity of legislation. So you might have a lot of judicial invalidation, not for anything to do with the judges, but because you had an extremely aggressive legislature dominated by politicians, unsympathetic or of different political character than the courts. Or you could have you could have simply a kind of different style of legislating. It might be, for example, in one era, statutes tend to be brief, and there's a lot of delegation of administrative agencies. There aren't that many statutes, and the most controversial portions of them are really in the regulations, which are going to be dealt with on a sub-constitutional basis. And then in the other areas, you may have just Congress writing these immense I mean, look at the health care. It's 2,700 pages long. Well, especially if you count partial invalidations as unconstitutionality, 2,700 pages must conceal some unconstitutional.
So the courts will be busy for a long time.
Busy, yeah.
All right, well, I'd like to thank Dick Posner, Aziz Huck, Lee Epstein, and also the Brennan Center for providing us this opportunity to have this great lecture as well as a commentary. And I'd like to invite all of you to join us outside the doors for take the conversation out there and get a chance to greet and talk with our speakers. So thank you all very much.